Hello and welcome to a new season of Interpreting India. Geopolitical realignments, sustainable growth, healthcare financing, inclusive digital transformations, climate change, supply chain disruptions, urbanization, and several other critical global matters envelop the world as India holds the G20 presidency. We at Carnegie India continue to bring voices from India and around the world to examine the role of technology, the economy, and international security in shaping India's future. The past week was momentous for those awaiting the enactment of a legal framework for data protection in India. India's parliament passed the Digital Personal Data Protection Act 2023, and the law has now also received the assent of the President of India. This law has been enacted after more than 5 years of deliberations and consultations. Multiple committees have submitted reports on the proposed legislation, and 3 previous drafts of the legislation have been circulated in public for consultation. This law, for the first time, creates a framework for protecting individual data privacy. All businesses collecting and using personal data will have to comply with the law across the economy. Consumers will enjoy certain rights with regard to their data. A data protection board will ensure that data is stored safely and issue penalties for non-compliance with the law. At the same time, the law provides exemptions and exceptions that some critics are unhappy with, and for others, consumers do not have enough rights and businesses do not have enough obligations. But even if the law is imperfect, it is a significant milestone in India's policy framework for regulating technology. The law will impose costs on all businesses across the economy, and the question is whether the gains with regard to data protection and privacy are worth it. To unpack these issues, joining us today is Mr. Rahul Matthan. Rahul is a partner in Trilegal, one of India's leading law firms, and heads the technology, media, and telecommunications practice of the firm. Over his career, he has advised on some of the largest technology and telecom transactions in the country, and he's an expert on technology, data protection, digital finance, cryptocurrencies, e-commerce, and related subjects. Rahul has advised the government on the data privacy law and also served on the Kris Gopalakrishnan Committee on non-personal data. He has authored numerous articles and thought pieces on various topical issues relating to computers, the internet, and other new technologies. His book, Privacy 3.0, Unlocking Our Data-Driven Future, addresses the challenges of regulating privacy in the big data world. Rahul, welcome to Interpreting India.
Thanks, Anirudh. Glad to be here. Thank you for having me.
Rahul, let's start with discussing the journey that this legislation has gone through. It's been more than 5 years, I think 6 years since the Portability judgment came in. And we've seen a significant shift in approach in how the data privacy law was initially envisaged and the final version of the law. So can you give us a background on what exactly this law went through? What were the main points of contention and how this law was eventually shaped?
Yeah, so I guess history always depends on where you start counting it. And when you say 5 or 6 years, I have to challenge you because for me, my journey with the data protection law started over a decade ago because shortly after the other program was announced, there was an attempt by the government at that point in time to enact a data protection law. And I was actually personally involved in drafting probably the very first version of it, somewhere around 2011, 2012. And then we had the Justice A.P. Shah Committee, which came out with a report. And I know that some of the work that I did had to incorporate some of that work. So actually, this journey is like over a decade long, if you think about people who've been thinking about this in the space for that long. And then in that arc, if you look at the evolution of the law, I'd say the first draft that we came up with was a very simple draft because your data protection was a relatively new concept in the country and quite frankly in the rest of the world. It was also before big data. And so data protection was a very different type of an animal at that point in time. But then when the Puttaswamy judgment happened and the Justice Sri Krishna Committee report came out, that was in 2018. We were already in the midst of big data and we realized that this required some significant regulation, or at least that was the thinking at that time. It was very much influenced by the fact that in 2016, Europe had enacted the General Data Protection Regulation. And GDPR, of course, came into force in 2018, but it was very much in everyone's mind that this is now the new gold standard as to how data protection regulation needs to, what it needs to look like. And so you'll see that the 2018, 2019 drafts and then, the JPC version, they all sort of emphasized this very, very heavy regulatory focus. And if you then contrast the latest draft that was sort of produced in 2022, and then this draft that has finally been passed, I think it's sort of going back to that very simple style. Of course, with modifications, but I think there's been a bit of a pendulum swing away from the complex regulation and compliance that the sort of Justice Sri Krishna draft and its offspring produced, to something simpler. Just an example of that is the fact that I think in the Justice Sri Krishna draft and the eventual JPC draft, there was something like 10 to 14 different types of things that needed to be notified before you obtained consent. And now there's essentially just two things, which is what is the data that you're collecting, what's the personal data you're collecting, what is the purpose for which it's being used. There are two other notifications in terms of grievance redressal and things like that, but those are more sort of standard format type notifications. And I think that is sort of something that is the hallmark, I think, of this latest version.
Yeah, thank you for correcting me on the origin of the discussion and the debate. I think I'd forgotten the initial impetus for this. And I think there's a very interesting symbiotic journey that Aadhaar and also the increase in broadband penetration in India has had, combined with this discussion on data protection. And I'd love to hear your reflections on this.
That's the uniquely Indian part of this, because everything else is India as part of a global economy that is increasingly seeing data as very relevant to the way in which the world works. I mean, if you just look around the world, there's the move, there's the rise of social media, but there's also e-commerce, and there's ride hailing and the sharing economy, and so everyone starts to see that side of things, but immediately, side by side with that, you realize the harms that can be caused as a result of this. And so a lot of the regulation around the world tends to orient towards completely tamping down on this explosion of data, because there are, in the minds of some, the risks are not worth the reward. But, in the Indian context, it's actually very different, because India, there's this famous saying that India became data rich before it became economically wealthy, and that data was being seen as the way to help India, in a sense, leapfrog stages of development to become economically wealthy using data. And so I think in India, there was this, I guess everyone recognized that there were risks, but there was also this need to empower people with their data. And so I think you see some of that reflected once again in the latest draft, because I think the emphasis is to make sure that in our attempt to, reduce the harms, reduce the risks that people can suffer, we should at the same time not overburden Indian businesses with compliance obligations. And that extends to other aspects of the law where, there are discussions around consent manager and things like that. I guess we can come to in more detail. But that is a hat tip to this entire ecosystem that's built up in India around digital public infrastructure. So I think that certainly played a part. I think the government recognizes that a lot of Indian development is still reliant on the way in which this digital public infrastructure ecosystem can play out. And so it recognizes, the risk of going down the GDPR route, because that could constrain some of these innovations. And so it tries to strike that balance between the two.
Yeah, and I think there are actually three parallel interests that are operating here. And I think we see that very clearly in how the different versions of the bill have worked out. One is, of course, what level of compliance do you want to impose on business, and what is the right level of privacy protections related to that? The second is, of course, this, or the third, I would say, is the actual issue of how the state can use data for welfare purposes and for purposes like pandemics, epidemics, and so on. And I think all three of these issues, the issue of individual privacy, the issue of compliance on businesses, and the issue of state use of data, I think there's been a continuous give and take on this. And I think we've finally seen some kind of balance in this version of the law. So let me move to the actual working of the law and just pick your brains on what is the broad structure that this bill proposes? How is it supposed to operationalize? What are the key components?
Yeah, look, I mean, I think it's not different in, material respects from what you'd expect of any data protection law. It's very much oriented towards the sort of notice and consent framework. It does differ from previous versions in that it brings in this concept of legitimate uses of data. And in that context, it allows for people who are looking to voluntarily provide their data. It gives some certain benefits to those, or rather, it says that you don't necessarily need consent in order to process that data. But that's a very narrow definition. It's not the legitimate interest definition that you expect in GDPR. So it's, other than this, it's a very heavily notice and consent type framework, and then you'll see all the other rights articulated in different ways: the retention restriction rights, the data minimization rights, purpose specification, use limitation. All of these standard data protection rights from around the world are all embodied in this law, not in the way that you would expect to see it, but it's certainly there. And then it has a bunch of rights that the data principals have. Those are the standard rights of access, correction, erasure, grievance redressal. It adds a new right of nomination, which is allowing data principals to nominate someone to act on behalf of their data. It also adds this new concept of duties, which is a little unusual in the data protection context. I don't think any other legislation, to the best of my knowledge, has imposes a duty on the person to whom that personal data pertains. But I think when I spoke with the minister as part of the consultation, he indicated that this is more a you've got to come to the courts with your hands clean kind of concept. And he's at pains to point out that the fact that you haven't performed your duty as a data principal is not going to affect your right to a remedy or a redress. But it is worth noting that this is it does place some sort of a burden on the data principal. Some of these duties are the duty not to impersonate and things like that, which I can see where they're going with this. So if you think about it, it's a stripped down version of a data protection law from anywhere in the world, but it does have a few nuances that are different, and I think that's where some of the discussion and I guess concerns arise. But I think that for the large part, this is you'll find, though not in the detail that one would expect, all of these things already implicit in the law.
Yeah, so on that point about this being much more bare bones, I think there are two different points of view. One is a far more pessimistic aspect of this, which is this is somehow going to foster a kind of wild west unregulated behavior where firms are basically going to comply for the heck of it and get away with it. And the other more optimistic view is that we are in the early days of technology and technology adoption in India, and this is actually the way to create some kind of innovation in having different practices around data privacy. And this could actually eventually coalesce around some minimum standards that would then prove to be the ground for a more detailed regulatory framework. Where do you come in on this?
Yeah, I mean, I hate to get drawn into these binaries, but, because I think it's important to first recognize that we are at a very, very nascent stage in data protection regulation in the country. We've had something called the data protection rules, sensitive personal data and information rules that are part of the Information Technology Act. And so you can argue that we've had some experience with it, but as a matter of fact, there's no institutional capacity to regulate under that regulation. So we literally have no regulators in a country with 1.3, 1.4 billion people for data. And so if we're going to go to a GDPR style framework, it's 0 to 100 or 200 kilometers from a standing stop. And that's almost impossible. You've got to remember that GDPR came into force after data protection institutions existed in Europe for over 2 decades. And so it's actually easy to go to that level of complexity because it's just a slight ramp up of what everyone was already used to at that time. That's not the case in India. So I think that we need to have some sort of a simple regulation to start with. But I don't rule out the need for tinkering with it to make it more robust where it's required. And now on top of that, if you layer on the points that you were mentioning, which is, the innovation side of things and things like that, I think that's also important. And so if we've got some amount of flexibility, and so, I know that it's likely to be a Wild West, that there would be a minimal amount of things that people have to do, and then they can really go wild around the edges. But if you think about the situation that exists right now, that's exactly what the situation that exists right now, because there are no regulations. People can do whatever they want. And so I think a small measure of regulation to start with is really the way to do it. And then I think we can ratchet on different levels of regulation where it's required. And that I think would be a more sensible way to go about it. I think, I think it's also perhaps an unfair characterization to say that there isn't compliance. There is compliance. I think some of the provisions of this law are actually quite stringent, perhaps more stringent than I would have even liked for this stage of evolution. Retention, for example, there is almost a automatic deletion obligation that's been imposed through this law, which no other law in the world has. And I think if I were to advise my clients, the only way that they can safely comply is actually just not to hold the data after they've used it. And that is a very, very big shift from the way in which people think about data protection and compliance. And if we can achieve that, that sort of an outcome, we would arguably be way more successful in coming up with the data protection outcomes than even countries like Europe. And so, I would actually like to take a look at this as it evolves, because there are elements in this that if the Data Protection Board actually enforces quite strictly, could have very, very different and beneficial outcomes for data protection compared to what Europe and the rest of the world are adopting as their models.
Yeah, that makes a lot of sense. And something else that you said is also, I think, worth reiterating, which is the point of complexity acting as a constraint on our ability to regulate properly. And I think the point that you made, that regulation in the EU has evolved over a period of 2 decades, and those are still the institutions that we are familiar with, but they actually have a lot of data protection legislation and jurisprudence going back even further. And I think when we look at a law like GDPR, it's basically the culmination of all of that taking place over 30, 40 years. And we've not had that. And I think when we look at the law, if we don't look at some of the underlying capacities and institutions that go into creating that law, for example, the entire ecosystem of lawyers, judges, specialists who understand how these things work. And if we were to implement something as expansive as our initial draft, our earlier drafts, it would really act as a serious constraint on our ability to actually implement that draft well.
Yeah. No, you're absolutely right. I just mentioned the regulator, but there is a whole ecosystem that we have to keep in mind. There are no lawyers in the country who know how any of these provisions need to be implemented. And that's, in a sense, part of the challenge with coming up with the law in the first place, because in many of our consultations, I could see that the government had, brought something in from GDPR, but didn't fully understand how that would relate to the Indian context or even the modern context. I mean, you got to also, to the point of complexity, you got to also recognize that GDPR is actually not doing that well in the very complex modern world that we have. I think the complexities are, in a sense, binding Europe in ways that that some businesses in Europe are actually rebelling against. For instance, this current generative AI boom. Europe and Italy in particular ended up banning ChatGPT just because it didn't comply with data protection regulations. And people are concerned about this. Threads, when it launched around the world, didn't launch in Europe because of the fear, and I believe it's still not available in Europe because of the fear of the new Digital Services Act coming in. So you can see how excessive regulation in Europe, we can actually see live examples of how very, very strong regulation in Europe is coming in the way of innovation and new sort of products coming into the market. And that's not what India as a country that's just starting out on this journey wants to do to itself. And so I think that's really something we've got to keep in mind.
No, absolutely. And let me just now move to some of the specific provisions of the bill and pick your brains on this. So one point that you alluded to is that some rights and obligations have been reduced. What do you make of this? So, for example, there's a right to data portability that was there in the previous drafts. It's there in the GDPR, and that's been reduced. And the other shift is also in the framing of the provisions itself. The earlier versions were far more prescriptive, gave much more details in how to actually implement some of this stuff, and this law actually does away with it. So, how do you make sense of some of these?
Yeah, I'm actually disappointed with the fact that we don't have right to data portability. I think that's one of the misses of the law in the consultation. I actually mentioned this point. I said, we've got to find some way to bring that back. In many ways, that is a provision that actually aligns with a lot of the DPI framework that we discussed earlier, which is, it's central to the concept that an individual has a right over their data, no matter where that data is, even if that data is under the control of some data fiduciary. The right of data portability allows that individual to say, give me that data. Right now, all the individual can do is figure out whether that data exists, and if it does, whether it's up to date, and if they want, they can delete it. So that's about it. But that's actually not as effective as it should be. What we really want is the ability to take that data out of that data silo, so that I can actually have it in my own possession, or instruct the data fiduciary to transfer to some other data fiduciary, so that I can swap my service provider, as it were. Now, that's a really powerful right, and I think, particularly in the modern world of social media and things like that, it is a right that exists. I think, arguably, India is moving towards this DEPA framework, DEPA, that is DEPA, not DATA, where we're trying to set up institutions that will manage this portability through consent managers and things like that. And consent managers have a place front and center in the law. So I think that's, in a sense, slightly mitigating it, but I still think that that the right to data portability ought to have been there in the final draft. But in terms of the prescriptive nature of the regulations, I think this is absolutely the right direction to remove some of that prescriptive obligations, as it were, on how these rights are to be enforced. Because I think it will vary in the Indian context. I think there are many nuances in the Indian context that we will just have to see how it evolves. So I think it's probably best to just articulate the provision. The challenge with that is it's a heavy burden on the regulator or the government, as it were, to try and come up with the prescriptions that I guess are going to be necessary from time to time. If you don't state up front how things are going to be done, then you as the government will have to almost set up an institutional framework to issue those clarifications, guidelines, regulations, as and when required. And you'll also have to do it sectorally. You'll have to, because they'll vary slightly per sector. So that is also something that I think the government needs to think about, and this goes to that whole institutional capacity. So I just hope that we will build this slowly but surely, but not so slowly. I think we're going to need to build this fairly quickly, and I think that really is where it's going to all be interesting.
Yeah, and while you were talking, I was also thinking about this added complexity in India, which is that a large number of our businesses are actually very small. And so you've not just got to think sectorally, but also in terms of what is the level of risks that different kinds of businesses actually pose in terms of data privacy, and whether you can actually start out with a heavily prescriptive law from the get-go, which might not actually attain that desired level of suitability for all kinds of businesses across the economy.
Yeah, and that's complicated by the fact that in particularly a startup ecosystem, we have some very small businesses that could have an outsized impact. These are businesses that could, do today, even though they're relatively small, affect millions of people. And as you're saying, there are many SMEs that they do deal with personal data, but that's not their main business. And so, do you want to just crush them with compliance? When quite frankly the risk is relatively small and minor. These are really difficult challenges to deal with. I don't think Europe ever had to deal with things like this, because one, Europe population wise is very, very different from India, and two, it took a really long time. So they very, very slowly eased into the big data world. I think they would say that they gotten faster than they would have liked, but still, if you just look at the whole arc of regulation, it happened over a period of time, and we just don't have that luxury. So these are difficult things to put into a sort of a prescriptive law upfront.
One of the things you alluded to is about consent managers, and that's something, again, of an oddity in the Indian law. Can you talk a little bit about this? You've been working on this for a while, so could you just explain what this is?
Yeah, this is a hat tip to India's data empowerment and protection architecture that is manifest in the financial services sector through the account aggregator framework. This is an institutional arrangement whereby all financial institutions connect to these sort of central consent managers that in a sense, intermediate data transfers by separating the consent flow from the data flow. So it's a very uniquely Indian innovation, but the idea is being discussed around the world. People are interested in this idea because it has many inherent privacy benefits. And so I think in the earlier drafts, I think in all the drafts, there was a reference to a consent manager, but that was more like a separate, different way of managing consent flows or managing the process of consent. In this final draft, and it is only when it sort of came up in the final draft, it has been elevated to the status almost, I would say, of a separate type of institutional actor. So you have, on the one hand, data principles, which is the equivalent of data subjects in the GDPR framework, the person to whom the personal data pertains. And then you got the data fiduciary, which is the equivalent of a data controller in Europe, is the entity that holds this personal data and controls the personal data. And that's essentially the entity that's regulated. And in the earlier versions of the draft, a consent manager was classified as a data fiduciary. But in this version, that hasn't been the case. In fact, all consent managers are stated to be consent managers that have to be registered with the board, which sort of presumes that the account aggregators that are currently registered with the Reserve Bank of India will also have to register themselves with the Data Protection Board. And so it's through all of this, it's one saying that this is neither a data principal, data fiduciary, or data processor. It's a new category, and it's called consent manager. And that consent manager will be directly regulated by the Data Protection Board, sort of elevating it to a different status. And that's really interesting. It's to me, it allows for a future where I can see perhaps cross-sectoral data portability. So, for instance, we've already got account aggregator in the financial services sector. Those are the consent managers for finance. You could eventually have a consent manager in the health sector, as an example. And then, in order to transfer data from the health sector to the financial sector, an example would be for health insurance or something like that. You could then have this cross-sectoral data portability that's enabled above the level of the financial and the health regulators, but at the Data Protection Board level. And that's really interesting if you think of the next stage of India's data architecture.
Absolutely. So, we were talking about portability earlier, but just to clarify, just because we don't have a right to portability doesn't mean we can't do it contractually, right? Still work.
Absolutely. It's just that I cannot, as a data principal, go to some entity that to whom I've consented to provide my data. My only recourse would be, under the law, would be to get them to delete the data. If I have a contractual arrangement with them, and most entities that operate internationally will already have this contractual this already there in their terms of service, that you can take my data at any time. That's because the right to data portability is available everywhere else in the world. But in the I guess the rare exception where there's a company that is not obliged to do that, we don't have a statutory recourse to fall back on, to say that you are required by law to give this to me. And that, I think, is sort of the sort of a miss.
On a slightly related note, there's one slightly strange provision in the law which I wanted some clarity on you from. There is this provision which basically gives a certain set of exemptions to government agencies to take data from another government database if it's already there, without the consent of the individual concerned. Now, I can understand the need for this if you're in the middle of an emergency or a pandemic or a war-like situation or something like this. But surely this is not something that seems legitimate if you are actually thinking about, say, social welfare purposes, where there's actually no exigency. So why do you think this kind of a provision, is either legitimate or makes sense here?
Yeah, that provision, if we're talking about the same provision, that's probably 7B, which is in the legitimate uses. Now, 7B actually limits the application of this particular right to providing subsidies or benefits or certificates or licenses, etc. And if you look at the illustration that they provide, essentially the illustration also talks about, you're entitled to a particular maternity benefit, but there may be, some other, or you enroll yourself as a pregnant woman in a hospital, say, but you are entitled to a maternity benefit that you didn't know and you were not availing. In that circumstance, it could potentially be pulled out of the sort of the health database into the maternity benefit database. So, I think in that sense, it is not as broad as we might have envisioned, where, let's say, for instance, the income tax database is being data is being ported to, say, the crime database or something like that. That I can see that we would all have some sort of issues against. But in where it is being done for the purposes of providing a benefit or a subsidy, you can see how the government is, in a sense, trying to solve a fairly wicked problem in society, that there are people who currently are entitled to avail certain things which would make their life better, but just because they don't know it, are not able to do that. And I think this is, in a sense, a manifestation of some services that currently exist. Of course, all these services exist using consent. But I think even the government would say, look, I've got this sort of benefit that I don't understand why people are not availing of it. Can I look into various other databases to see if there are other signals that people are entitled to this benefit, and can I then share it with them? So something along those lines.
Sure, I understand that. My only problem with this was I did not envisage consent being a binding problem in this issue, or taking consent from the individual concerned, because it's also become fairly easy to do that in most cases today. The fact that this is not an emergency or an exigency actually added to that.
No, but I think to reach out to the person to ask for consent, you would. So it's sort of the reverse, right? So if I am entitled to a maternity benefit, I need to know that the person is pregnant in order to know that the person is entitled to maternity benefit. This is a bit of a chicken and egg kind of a thing. So can I, as the maternity benefits department, reach out to all hospitals and say, give me information of pregnant women so that I can then reach out to them? Now, in order to do that, I would need consent. And so it's sort of it's a different agency and instrumentality that's actually looking for the data. And how do you give that entity the ability to do this? Now, it would be terrible, as I said, if the police used this, but the police are not providing us a subsidy or a benefit. And so I would argue that if the police tried to leverage this provision, that would be excessive and would not be permitted under 7B.
Thanks. I think that clarity is helpful. There were a couple of other provisions that struck me more specifically about not government powers per se, but the level of unfettered discretion that the government has. One of these was about giving exemptions to any data fiduciary or class of data fiduciary from any part of the law in the first 5 years of the implementation of this law. Now, I don't have a problem with exempting certain industries, certain sunrise industries and so on for an initial period to help them actually implement this law. But there is actually no guidance or legislative language that would actually channel the exercise of this power. And in addition to that, there's no time limit for this exemption itself. So the law only says that you can use this power for the first 5 years. I think this is section 17.5 or 17.6 of the law. And what worried me was it actually enables the government to use this power almost without any guidance, which is not to impute any intention on any specific government or so on, but it's just a provision that should have been better drafted.
Yeah, I agree from the way you're framing it that it would have been better for us to have some guidance as to how this would be used. But having said that, I think we keep looking for the guidance in the words of the statute, and I think it's good where it's available to have that guidance. It acts as a fetter on the state. But the fact that it's not there doesn't mean that there is no guidance and no fetters. I mean, we're the state, because this is specifically that the state has to notify that a provision of the Act will not apply. And in order to do that, the state is constrained by the threefold or fourfold test laid down in Puttaswamy. And so it's not like as if they can just do whatever they want. It can't be excessive. So, I mean, I would say that we do have some restrictions and protections on the state. The fact that subsection 5 of section 17 exists off of itself is not ultra vires of anything, because it's just like an enabling provision. But if we find that there is some kind of implementation of this, we have every right to test that against the Puttaswamy judgment, and then the government has to show that what it's done is in conformity with that judgment. I think that the thinking of the government is, as you said, one, Sunrise Industries, but perhaps also just the whole sunrise nature of data protection, and that in some instances it is actually going to be hard. I just take that data retention point that I mentioned, this automatic deletion of data. If you implement this immediately, it's going to be impossible for companies. I mean, companies will be violating it from day one, because there's already a whole cottage industry around collection of data and use for telemarketing and things like that. And it doesn't help anyone to declare that the whole country is guilty of a law the moment it comes into force. And so I can see some of those sorts of use cases for something like this. Of course, we've got to be vigilant, and we've got to just hold the government's feet to the fire whenever they come up with any notification under this, to make sure that it's not excessive, it's proportionate, it makes sort of sense. And so that's our duty, as people who are watching this and commenting on this, to basically look at that. But as it stands right now, I would have liked it to be more specific. But whenever I say something like that, I worry that if we specify, then it's impossible for us to think of every possible scenario, and we'll leave things out. And then there would be some really legitimate things that need to be covered by this that can't, because it's been left out. So that's sort of the challenge.
Yeah, I mean, I'm thinking of a worst case scenario where you could potentially exempt certain industries from the entire law, right? Because any would include all, and you could just, that's a potential, and you're right that it will probably not work that way. And I completely understand that there are difficulties in guessing how you would actually need to use this provision going forward, because it's a completely new law. The other provision which stood out, and people have been talking about it, is this section that enables the government to block access to information from certain data fiduciaries. And there is a kind of legal process given within the section. But the question for me really was, how is this related to data protection? And does it actually stand in a data protection law at all?
Yeah, no, I have to agree. I was very disappointed with 37(1)(b). I thought it had no place in the law. It didn't exist in the previous draft. And so, none of us had the opportunity to see it and comment on it. And it literally came out of the blue. And so, I spent some time thinking about what might have been an appropriate type of provision. And if you think about it, this is a law to protect digital personal data. And so if we've got a website that is broadcasting personal data of people, I can see how a blocking order in relation to that website would make some sense. So I can see that is an appropriate kind of blocking order in the context of a law like this. So if that particular provision had that kind of a limitation to say that it would only be applied to that, it would make some sense for me. But as it's written now, if you look through the statements of objects and reasons, if you look through just the parameters within which this law has been enacted, it far exceeds that. If it's challenged, I'm sorry to say, I believe that this provision will be struck down. It's far in excess of what the government should have put in there.
Yeah, and it came about as a complete surprise. It wasn't there in any of the previous drafts. None of the committees that have studied data protection in India have recommended anything like this. And ideally, it would belong in, say, the IT Act, which actually regulates the behavior of.
And it exists. I mean, see, right now we have blocking orders in the IT Act. I suspect that the Digital India Act that's being drafted will also have something similar. So putting it in here seemed completely out of place. And I think it will be struck down if it comes up, if it's challenged before the court.
So we are nearing the end of the conversation. I had two more questions for you. One was on the issue of data localization, and there's been a lot of debate and discussion around it. And this draft basically does away with it, so to speak. So is that your interpretation of this, and how do you see it?
Yeah, with one exception, I think it allows for sectoral regulators to impose, whatever additional provisions they want. I think that recognizes the fact that in the financial services sector, there are already payment localization regulations and things like that. But if you look at it from the 2018 draft, which is the first draft that mentioned the concept of data localization, through to even the 2022 completely revamped draft that had sort of indicated that there would be a list of countries, but other than that, it would be permitted. And I remember it was at a Carnegie event that I suggested that list would actually be sort of a blacklist as opposed to a whitelist. And it looks like even my fairly optimistic interpretation has been exceeded by no list at all. And so it looks like there's going to be a free flow of data, which is, in a sense, as it is right now. So data localization was going to impose a heavy burden on companies that have oriented their business around the way things currently are.
And my last question is about the implementation of this law. How do you think the government is thinking about implementing it, either in one go or in a staggered manner? There are also institutions that need to be set up. There's a data protection board that needs to be created. So do you have any ideas on what that implementation framework is going to look like?
Yeah, two parts to that. I think, whenever we've spoken to the minister over the consultations, his big emphasis has been to ensure there's complete clarity around the legislation. And he says that when this is brought into force, it will also be accompanied by the complete list of regulations. So, comprehensive regulations. There's a lot, as people have been saying, that are left to be prescribed by regulation. And he kept saying that that entire book will be available. So there's that one side of it, which is there's a fair bit that's been left to delegated regulation, and someone needs to be compiling all of that before the act is actually notified and brought into force. I think that's essential because certainly for some aspects, there are immediate requirements for clarity that can only come through the regulation. And the second aspect, of course, is the data protection board, because there is a need to have, particularly in a principle-based regulation like this, which is simple, then you need to have some institutional authority that could then add color to those very simple outlines. And that is the data protection board. So the moment this comes into force, we're going to need to think through how the bare law plus the delegated regulation applies to all of the various industries in the country. And we will be taking calls because there's no guidance. And so, companies will be doing certain things. They'll be, in the absence of guidance, they're going to be saying, look, this is the way we are interpreting this. And people will object to that. Those objections, those complaints will have to come up before someone who will then have to say, yes, this is correct or this is not correct. And through that whole process, we'll start building the precedent bank that is going to shape data protection regulation in the country. So we need the data protection board as well. So I think these are the two components of this, as it were. the government will have to put this in place. I think it's almost essential that they put all of this in place before the act comes into force and applies to all of us.
Thanks a lot, Rahul. You've been a part of this process for a long time now. Do you have any closing comments on this bill, on this law now? I'm glad we don't get to call this a bill anymore.
I know. I'm glad. I'm so used to calling it the Data Protection Bill that it's going to take a bit of effort for me to change it to Data Protection Act. So it's going to be a mental shift for me. But I guess the most important thing is that whether we like it or not, this is the law. And I think all of us in civil society who've been orienting ourselves, and I don't call myself civil society, I guess all of us who are commenting on the law have been orienting ourselves to provide inputs as to how this could be made better. Now that time has passed. It is what it is. This is what we have to work with. And so now we need to start shifting gears, as it were, to start thinking about how we can help the government think through a lot of these institutionalization, operationalization means. That's sort of where the intellectual capabilities of this community has to shift to, such that we can be of most value. I think there's still a lot that can be done in that side of things. So I just wish that. I think there's a lot of venting that's happening. People are getting it out of their system that the law is not what they wanted, and there are a lot of people, leveling all sorts of allegations against the government, and the opposition walked out, and they're very upset that there was no debate. Not like, quite frankly, that debate would have made that much of a difference. I think I get it that we have to get that out of our system, but then there's a lot of work that this really wonderful technology policy community in India that has actually literally been built from scratch around this 5 or 12-year journey, whichever way you count it, of data protection. They've come up around that. And it's time for all of that intellectual horsepower to be applied to a different purpose. And I hope that we can all step up and do that. Certainly that's where my focus has already shifted. I stopped thinking about what I can do to the law because, quite frankly, there is nothing. And now I'm focused on what we can do in this next stage, and how can we help the government think through some of these actually fairly thorny things that they're going to have to decide very quickly as they prepare the regulations and constitute the board and things like that. So that's really, I think, where I'm going to be focusing most of the rest of my time.
Thank you, Rahul. That's a great note on which to end this. It's been a great discussion. Thank you for your time.
Thanks for having me.
We'll be back in 2 weeks with a new episode. To make sure you don't miss it, be sure to subscribe on Apple Podcasts, Spotify, Stitcher, or wherever you get your podcasts from. To learn more about our research and team, you can visit us at carnegieindia.org. You can also find us on social media on Twitter, Facebook, and Instagram. Thank you for listening. See you next time.